about what intellectual property is and its different aspects of intellectual property rights. So going to the first slide. So what is IP? IP is creation of human intellect or intelligence, which grants the owner certain negative rights. Can you see the screen?
Yes, sir, it's
Yes, sir.
visible.
Okay. Negative rights, which are legal or statutory rights, or which are exclusive or monopolistic rights. So if we understand what intellectual property rights is, it is the creation of human intellect which may give the owner of intellectual property right a right which is a right in itself or a statutory right that is subject to registration, and it would give a negative right to the owner of intellectual property rights, who in turn can stop any third person from doing the same or exercising the same. So there can be a legal or statutory rights, and second, these rights are exclusive to the others and are monopolistic. So once you have the rights, you can stop every other person without your permission to do a certain thing. So that is negative right. Yes, madam. Next slide. So what are the forms of intellectual property rights? These basically broadly divided into patents, trademarks, copyrights, and designs. These are divided into four acts, that is Patents Act of 1970, Trademark Act of 1999, Copyright Act of 1957, and Designs Act of 2000. So that gives us the procedure and the rights which are granted to a person who actually applies for either patent or trademark or copyright or designs. So next slide. If any person has got any difficulty or any questions, they can anytime interrupt me. They can interrupt me and we can continue with it. So patentable subject matter. Now, can you just go to a slides previous? Yes. So we should understand what a patent is and what is the scope of patentability under the Patents Act 1970. So basically, patents are given for an invention which qualifies according to the Patents Act 1970. So the definition of invention is given under section 21J of the Patents Act 1970, which reads as invention means a new product or process involving an inventive step and capable of industrial application. So there are certain criteria which is being given to define what the invention means, and it should qualify those criteria such as it must be relating to a new product, it must be relating to a process which is new, and it must involve an inventive step, and it should have a industrial application. So subject to fulfillment of all these criteria under section 21J, a patent is granted to an inventor or the applicant. Next slide, please. So this invention must not be absolute. It is subject to various excuses and various inventions which are not subject matter of the Patents Act. So what are those inventions? It means or relates to a product or process or both. It should be new. It should involve an inventive step. It should be capable of industrial application, and it should not fall under section 3 and section 4 of the Patents Act. So all inventions are not patentable. Inventions which may qualify as a process or product which is new, which has inventive step or industrial application, but which are falling under section 3 and 4 are not patentable. So section 3 and section 4 gives statutory non-patentability in spite of making an application for grant of patent. Yes, madam. Next slide. So this is the procedure for obtaining a patent in India. Typically, the period is given on the left-hand side and how the process is on the right-hand side. So once you have an idea and once you feel that it is a patentable subject matter under section 21J, you have to start the process by writing what your invention is and file what is called a provisional specification. Followed by that, within a period of 12 months maximum and subject to post dating the application, you have to file complete specification with the Patent Office Mumbai. Once the complete specification is filed, it should be published, or as per the act, it is deemed published. So after a period of 18 months, the application which is filed as patent is published in the IPO, that is Indian Patent Office official journal. Once it is being published, you have to make a request for examination, and subject to making the request for examination, FER is issued. Now what is FER? FER is first examination report, and subject to compliance and subject to oppositions if any, the patent is either granted or the patent is rejected. Once the patent is granted, you have to pay the renewal fees. If there is any infringement, you get the right to sue others, that is to enforce your negative rights after you get the patent to stop others from doing it. So if you can just recap about what the patent is about, you have to go and file a provisional application. It should only give the title of the invention. It should only give the anticipated results, followed by a complete specification, which would be broad in nature. You have to explain exactly what your invention is. You have to explain what the patentable subject matter is. You have to make out the criteria as defined in the Patents Act, and it should have the set of claims for which you are claiming the protection from the Patent Office. Once it is been done, normal publication after 18 months, subject to filing request for examination, FER is issued, subject to compliance, and if any opposition after successfully completing the same, either a patent is granted or rejected. If the patent is granted, you have to pay renewal fees to keep the patent in force, or if you know that somebody is infringing the patent, you have the right to go and sue him and stop doing the same thing. So this is how a patent application moves from the date of application till it gets its grant from the Patent Office India. Yes, madam, next slide. So the rights granted, as I said, negative rights and all, it is already dealt in the first slide. So I have not once again reproduced it. Next slide. Now, what are the remedies in case now you have a patent and you come across somebody who is infringing your application or infringing your patent application? You have the remedy to go to the court of law and file the suit for injunction and get stay from doing a particular thing. You can also ask for the damages, that whatever damages that is being caused by the potential infringer, you have to get back all the monies which otherwise would have been to your accounts. Then you have to ask for disclosure of accounts and handing over of the profit which the person might have earned by infringing your patent. And doing so, you can have an appointment of court commissioner or court receiver by the court of custody. Public sealing of infringing materials and accounts can also be done. Now this injunction, when you come across this injunction, can be ex parte. Now ex parte means without informing the other side or the infringer, or it excuse me, or it can be after hearing. That is, once you have the patent, you give them the notice that unless you stop infringing my pay product, I have all the rights to go to the courts of law and enforce my right. But if the person has not stopped in face of the notice, then you have to give him the papers, and after hearing both the sides, interim injunctions have been granted in the past, and that can be the normal practice. Next slide. Now, trademark means any sign or it is being given under Section 2 of the Trademarks Act, meaning anything that can be represented graphically, and for example, Colgate, for example, Godrej, for example, any other thing which you can see as a trademark. So it's a normal definition under the Trademarks Act 1993. Next slide. Now, how a trademark is obtained. Once you have the trademark, you have to go and file the application for registration of the trademark as you have in case of patent. Once you file the applications, there is no need to file request for examination of the trademark application. Automatically, after receipt of the application, the examiner of the trademarks is duty bound to examine your application. Then after examination of the application, he gives acceptance and publication of the application takes place. After publication, if any person interested or any other person who feel aggrieved by such opposition, such application, may file opposition to such registration. And after successfully handling the opposition, either the trademark is granted or rejected. So this is normally the process for registration of trademark. Yes, madam. Next slide. Now, enforceability, as we have seen in case of patent, that what are the remedies that is been available in the act. Same remedies are available also under the Trademark Act with certain caveats that how they are to be enforced. First is you have to file the suit for infringement and passing of action, which is a civil remedy. The relief includes injunction, damages or accounts of profit, and 10-pillar order for search and seizure of the infringing goods. Then you may file the criminal complaint, from where either you have to make the application to the magistrate to get an order for search and seizure of the infringing goods, or you can directly go to the police, and the police officer not below the rank of DSP may also search and seize the infringing goods after obtaining the opinion of the Register of Trademarks on the question of infringement. So you have to apply, as I have said it in my first slide, that some rights are statutory. So only when you get a trademark registered or a patent registered in your name, you have all the rights to go and stop a third person. Without making application or in the pendency of the application, you do not have the right of enforceability. You do not have the right to go to a civil remedy. Neither you have a right to go to a criminal court to get the search and seizure orders in respect of trademarks or patent. Next slide. Now, what are the salient features of the Trademark Act? As you are aware, prior to this Act of 1999, there was an Act of 1958, the Trademarks Act. There have been certain objections and there have been certain suggestions to the government of India for better enforcement of the trademarks. And government in the year 1999 has come up with the Trademarks Act 1999, thereby repealing the earlier Act of 1958. And the salient features are as follows. First, registration of service marks which were absent in 1958 Act. So therefore, services like information technology, software, BPO services, hotel, cinema, hospital, airlines, insurance, bank, investment business, chartered accountant practices, consultants, advertisement agencies, including the educational institute, can now register their mark as a service mark. There is no definition of the service mark. However, service mark means trademark, and the mark which is being used in relation to the services is called service mark. Then there is another protection given to well-known trademark against misappropriation. For example, we all know Apple for computers. So if any person uses Apple for any other services, it would amount to infringement of the well-known trademark Apple and passing off, and therefore injunctions can be granted to protect the well-known trademark against such misappropriation. So that is the another salient feature of the Trademarks Act 1999. Next slide, please. So there is also change in the civil jurisdiction of the court pertaining to infringement and passing of action. For example, in 1958 Act, you have to go where the infringement is taking place. But under the new Act, once you register your trademark, you have the right to file the suit for infringement where you reside, or the plaintiff or the person who has registered the trademark resides and voluntarily carries business in the jurisdiction, and the defendant has to come all the way and fight in your jurisdiction. So that is another most salient feature which has been introduced here in the Trademarks Act 1999. Provision of additional remedy against criminal offenses has been given. As we have seen, criminal offenses has been made a cognizable offense. So you means cognizable offense. Cognizable offense means an offense which can be enforced through police without any formal order from the court. So if anybody found to be infringing your trademark and upon meeting certain conditions, the police has right to go and seize. So any police officer not below the rank of DSP on obtaining an opinion of the registrar of the trademarks on infringement can search and seize without warrant the goods, dies, blocks, machine plates, etc. involving the committing of the infringement of trademark, which is a criminal offense. Then Constitution of Intellectual Property Appellate Board, which is now been abolished, and all the appeals are now with the High Court. Since it's little older slides now, this year in the Tribunal Reforms Act, the Intellectual Property Appellate Board has been abolished, and any order passed by the Registrar of Trademarks or Controller of Patents and Design has to go to the respective High Court where the office of the Controller General is situated, because there is no appellate authority in existence as of now. Next slide, please. Provision of single register of trademark provides a single register of all trademarks, eliminating two parts, namely Part A and Part B. So if you see in 1958 Act, if the mark is inherently distinctive, then it would go in Part A, and if it is a descriptive mark, then it would go in Part B. But now, after coming of this Act, there is a single register of trademark. Certification trademark authorities to register certification trademarks now vest with the registrar, whereas earlier it was with the central government. So if you have to obtain a certification trademark, then you can go to the registrar of trademark, make application, and subject to making certain submissions and documents proving, the registrar has the authority to register your mark as a certification trademark, like BIS you have. Provision of filing multiple applications. Previously, there used to be a single application for registration of the Then there is a prohibition of part of corporate name or name of business as trademark. Some of use of some else's trademark as a part of corporate name or name of business concern is now prohibited by adding a particular section 29, 5 and 6 in the Register of Trademarks Act, and it can now be enforced as a trademark. Next slide. Now, term of registration. Once you apply for the registration of mark, subject to getting your registration, you have a validity of 10 years, which is been increased from 7 years of the earlier act, and subject to further renewal, the registration is permanent or it is perpetual. So as long as you are paying the fees, the registration stands in your name. Then there is a provision of collective mark. Concept of registration of collective mark has been introduced. Collective mark means trademark distinguishing the goods or services of members of an association or person, not being a partnership, as proprietors from those of others. Now, what is the scope of infringement? Scope of infringement of trademark has been widened now. For example, use of a registered trademark as a part of corporate name, or use of a mark which is identical or deceptively similar to a registered trademark, even in respect of dissimilar goods or services, will be regarded as infringement of the trademark. So next slide. After the trademark, we come to the third aspects of intellectual property right, that is copyright. As you all are aware, and I have said it, it is being governed by the Copyright Act of 1957. So what copyright means, which would be useful for your educational institute, because there have been many papers published and written by many of the students or faculty. So for which you must go for copyright registration under the provisions of Copyright Act 1957. So what copyright means, a right to copy or reproduce, and it is always in respect of work, namely either a literary work, a dramatic work, a musical work, or an artistic work. It would extend to cinematograph film, so also it would extend to sound recordings. So anything which you have done by putting your skill and labor is subject to copyright, which is broadly divided into A, B, and C. That is literary, dramatic, musical, or artistic work A, B, cinematograph, film, and sound recording C. So if any of the work is being created by any person, he has a right to go and file for copyright application on his own name. Next slide. Now, what is the scope of the work that is been included in the Act? Literary work means what? Literary work includes books, compilations, articles, magazines, newspapers, computer programs, and databases. So any of the work is being created by you, or any of the work is being jointly done by any of or all of you, then you can have a right to file for application of registration of copyright under literary work if it is falling as either as a book or a compilation articles or magazines or newspapers or computer programs and databases. What is dramatic work is definition is given. Dramatic work includes play, any piece for recitation, choreographic work or entertainment in dumb show, the scenic arrangement or acting from which it is fixed in writing or otherwise. What is musical work? Musical work includes works of music and graphical notation of such work, but does not include any words or any actions intended to be sung, spoken, or performed with the music. So musical work would only include the work of music and graphical notations of such work, but does not extend to any words or any action intended to be sung, spoken, or performed with the music. That would fall under different thing. And finally, artistic work, which includes painting, sculpture, drawing, engraving, or photograph. So any of the work is being done by you during the term, then you have to apply for registration of copyright, which is a voluntary application. And as I say, registration of copyright does not give you any statutory right. That means once you create something, you actually have the right in it, but you have to prove it. Or if you make an application for registration, then it is deemed proved and you would be considered as prima facie author of that work. So this is the scope of work under copyrights. Next slide. Now, as I said, it would extend to cinematograph films as well as sound recording. So the definitions are given. What cinematograph film includes? It includes any work of visual recording on any medium produced through a process from which a moving image may be produced by any means and includes a sound recording accompanying the visual recording. Then what is sound recording? Sound recording means a recording of sounds from which such sounds may be produced regardless of the medium on which such a recording is made or the method by which the sounds are produced. So these are the definitions of all literary, music, dramatic, artistic, cinematograph, and sound recording, which can be protected as copyright under the provisions of Copyright Act 1957. Yes, next slide. Now, what are the rights granted once you have the copyright? Or rather, I would say, what are the rights once you have a copyright? Once you create any work, you have the exclusive right to reproduce the work. You have exclusive right to make copies of the work, to communicate the work to public, to translate the work, to adapt the work. In case of computer program, additional right to sell or give on hire copies of the computer program, which all are exclusive right. A to F, all are exclusive right to the exclusion of any other person than the author or the applicant under the Act. Next slide, please. Now, enforceability is same as in case of trademark. You have a right to go and file a suit for infringement of copyright and get injunction from the court as you have in trademarks, as well as you have a criminal remedy. So I have not reproduced it here. They are the same as they are in case of trademarks. Next slide. I think we are done with the slides. I have not covered design for the sake of time, but design means any article or aesthetics which can be judged through naked eye. So if you have a new shape of a glass or engraving or surface pattern, then you can go under registered design, and it is being governed by the Act of Designs Act 2000. So it is exactly the same. Once you register the design, you will get the copyright in the design. The term is 15 years, subject to renewal after 10 years, and maximum of 15 years. Thereafter, it would fall in public domain. The rights and the enforceability includes only civil right and not criminal remedies, as you have in case of trademark and copyright. So these are the various aspects of intellectual property rights, and subject to making applications and getting the mark or the patent registered, you have certain rights granted upon you for a limited period of time, in which you have the right to exclude any other person from doing the same act. So if you have any other questions, they are welcome.
Yes, if anyone has any question, you can write the question in the chat box right now so that we can easily coordinate. Or anyone want to ask anything, they can unmute themselves and ask.
Hello, sir.
Yes, madam.
Hello.
Yes, madam.
Sir, can you please share us the forms or the other detailing regarding that pro forma with which we can proceed? If you could.
Which for in respect of what? Patents, design, trademark, or
Patents. Patents.
patent? I will
Patents.
say.
Okay. Thank you, sir.
I will share. I will share with madam which email address I have, and then
Okay.
madam can
Okay.
share with you.
Okay, sir. No issue. Thank you.
Yes, anyone else want to ask? Okay, so it was indeed a wonderful session, sir.
Thank you,
Now
ma'am.
I call upon Dr. Vinita Joshi, Assistant Professor of Department of Medicine, to give vote of thanks.
So, this was ended a very enlightened session. Good afternoon to all. I, Dr. Vinita Joshi, Assistant Professor in Medicine Department at YMT Homeopathic Medical College, deem it a great honor and privilege to propose the vote of thanks on this occasion. First and foremost, I would express my gratitude to our chairman, Dr. G.D. Pol sir, who is constant source of our inspiration, support, and guidance. I would like to express my sincere thanks to our principal, Dr. Page ma'am, for providing encouragement for this webinar. I also want to give my sincere thanks to our Vice Principal and Dean Faculty of MUHS, Dr. Bagal sir, for his enormous support. I extend a very hearty thanks to HOD and Professor of Medicine Department, Dr. Vasika Seria ma'am, for constant encouraging and guiding us. I extend my gratitude to our today's speaker, Advocate Murlidhar Khadilkar sir, for his effort to explaining and clearing our concepts, enhancing our understanding pertaining to the IPR. I would also like to thank my departmental colleagues, Dr. Sachin Chokakar sir, Dr. Samir Paul sir, for who are associate professor in the department, and Dr. Arohi ma'am, assistant professor in the department. A special thanks to organizing committee, teaching and non-teaching staff for their unflinching support and coordination. And Mr. Prashant Gatre sir is, and his IT team for technical arrangement. And lastly, heartfelt thanks to our wonderful audience for their active participation. With this warm words, we move towards the end of this webinar. Thank you.
Thank you. Thank you. Thank you for the patient hearing. Thank you very much. Have a good day.
Thank you, sir.